Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps our channel grow. For today's case, we are dealing with conditions in prisons in the state of Virginia. This is the case of Albert Smith versus Dennis Collins. In this case, a prisoner was held in isolation for an extended period of time, and the court has to determine whether or not that is proper under the various provisions of law. So we get to look a little bit about how prisons make these kinds of decisions in terms of where inmates are housed, what their different options are, how they assess risk rate, and what the more advanced options under those rules can look like. So let's get started with this. Smith is currently serving a 44-year sentence in Virginia's custody. In November of 2010, he was placed in Virginia's Department of Corrections Grooming Standards Violators Housing Unit. So the way that he was keeping his hair did not please Virginia, so they have a housing unit for that. Until recently, Virginia's grooming policy, the operating procedure, required prisoners to keep their hair at a certain length or be moved to some form of alternative segregated housing, such as this special unit. Smith asserts that as a practicing Rastafarian, he cannot cut his hair without violating his religion. So we set up the plot. Smith here is a Rastafarian, at least according to him, and he'd like to keep his hair longer in accordance with their religion. Virginia at the time didn't allow for this, so they kept him in a special unit. And so this started his path on his violation journey to more and more restrictive kinds of punishments. This isn't the only thing he did, as we'll see, but it was one of the things that started him along the way towards more intense confinement conditions. Several months later, in February of 2011, Smith was transferred to Wallens Ridge State Prison on an emergency basis after he was accused of assaulting a correctional officer at Keene Mountain. Wallens Ridge is one of Virginia's twin maximum security facilities with segregation units for holding prisoners in a long-term solitary confinement. Shortly after he was assigned to Level S, which is the strictest level of supervision that Virginia used under this system, Smith was transferred to Virginia's other supermax facility, Red Onion State Prison, for intake, orientation, and assessment, and he remained in administrative segregation there until he transferred back to Wallens Ridge in July of 2013. In mid-2012, a little more than a year after he arrived at Red Onions, he began participating in an earlier version of the segregation reduction step-down program. So he was kept in solitary confinement for some period of time, and during this period of time, he apparently assaulted a guard. And so as a result of this, they basically gave him the highest offender level status and put him into a permanent solitary confinement condition. So he was put there in the one prison, and he was transferred back and forth between the other prisons. He was kept in this isolation condition for an extended period of time. So that's perhaps improper, but we're going to learn a little bit more about the standards that govern this. The stated purpose of the step-down program that he was on is to establish procedures for incentive-based offender management that will create a pathway for prisoners housed in segregation to step down from security level S to lower security levels in a manner that maintain the public, staff, and offender safety. Upon successful completion of the requirements of the program, offenders can step down from the S level, which is the highest tier, to the next highest tier, which is level 6. Once Smith began participating in the step-down program at Red Onion in 2012, he quickly advanced from stage 0 to stage 1. Although an internal review recommended that Smith advance to level 2 in 2013, the recommendation was not approved due to Smith's purported failure to comply with the grooming policy. So here again, the grooming policy comes to be a thwart in his side. So this is a multi-step program that Virginia has, and it has multiple stages. It has stage 0, 1, 2, and 3. And if you complete all those stages, you get reduced from S tier to the next tier down, which is tier 6. And presumably you could be further reduced down as programs or needs may require. But he completed step 0, which presumably is just the beginning of it. He actually made the first check mark, and someone said, oh, we should give him the second check mark too. And they said no, because he wasn't complying with the grooming standards. So his refusal to groom prevented him from advancing in this program, which meant that he was kept in a permanent solitary confinement situation. During his nearly 4.5 years in administrative segregation, which you should read as solitary confinement, so he was in there, solitary confinement, for 4.5 years at Wallens Ridge, and for 2 years prior at Red Onion. 6.5 years he was in solitary confinement. Smith was confined in highly restrictive conditions. Okay, so what does solitary confinement mean, at least in Virginia? I'm so glad you asked. Here's what solitary confinement means, at least in Virginia. He was confined alone in a 9x14 cell for 24 hours per day on non-recreation and non-shower days. He was only permitted to leave his cell for showers 3 times a week, so every other day, and for recreation in an 8x14 fenced cage 5 times per week, though recreation was frequently canceled. Every time he left his cell, he was subjected to a highly invasive strip search, and he remained in shackles. He was required to eat his meals alone in his cell. Almost all human contact was prohibited. Any visitation opportunities were conducted through glass walls, and he was limited to 2 brief phone calls per month. His cell door was solid metal and outfitted with metal strips to prevent communication with other prisoners. The light in his cell remained on at all times, dimming only a little bit at night, and he faced further discipline if he attempted to cover the light in an effort to sleep, and he was unable to participate in rehabilitation programs. As a result of these conditions, Smith attests that he was suffering from untreated mental health issues due to being isolated in segregation for so long. He also claims he was denied the ability to accrue good time credit while in administrative segregation. So what will surprise what surprise maybe some of you, is what solitary confinement really means. And this is what it really means. It's not good. Obviously, different prisons in different states have different rules in terms of the shower and recreation thing. But this is vaguely in the ballpark of what solitary confinement looks like pretty much everywhere. You're kept in a cell for 23 hours or 24 hours a day. Sometimes you get recreation every day or shower or something. This guy only got showers 3 times a week, and during recreation days, they were often canceled. He eats all his meals alone, and the light in his cell never turns off. So there's all that. And so he was deprived of all human contact in this situation for extended periods of time. Solitary confinement is not good. It is a strong motivator to remain in good favor with the prison guards. So it's like, how can we punish people even more if they misbehave in prison? Well, this is one of the mechanisms we have, for better or worse, so there's that. The district court granted defendants' motion for summary judgment on September of 2018. In doing so, the district court relied primarily on Smith's failure to establish any genuine dispute of material fact as to the atypicality and hardship of the conditions of the segregated confinement for pathway prisoners like Smith, and thus as to the existence of a protected liberty interest for the purposes of the procedural due process. So the district court said there are no facts in dispute that would lead you to conclude that this was atypical or unduly hard. And then the court notes that the touchstone of the inquiry into the existence of a protected state created liberty interest in avoiding restrictive conditions of confinement is whether such conditions impose an atypical and significant hardship on the inmate in relation to the ordinary incidences of prison life. The Due Process Clause of the 14th Amendment provides that no state shall deprive any person of life, liberty, or property without due process of law. To establish a procedural due process violation, Smith must satisfy a 2-part test. First, he must demonstrate that he had a protected liberty interest in avoiding solitary confinement as a Level S prisoner in the program at Wallens Ridge. Second, he must prove the defendants failed to afford him a minimally adequate process to protect that liberty interest. The district court held that the first requirement of the prong was satisfied because the policies provide for a security level review for prisoners in this program every 90 days, and defendants do not challenge that conclusion. Instead, the parties' dispute centers on the second requirement, namely, whether conditions of the confinement as a Level S prisoner failed to constitute an atypical and significant hardship as a matter of law. So they don't really dispute the facts, they just dispute the legal conclusion. Whether confinements are atypical and substantially harsh, in relation to the ordinary incidents of prison life is necessarily a fact-specific comparative exercise. In this case, we must compare conditions in administrative segregation at Wallen's Ridge to the ordinary incidents of prison life, which for Smith means conditions in the general population. Drawing on Supreme Court reasoning in Wilkinson, this court has construed the atypical and significant hardship analysis as turning on primarily three factors: the magnitude of the confinement restrictions, where the administrative segregation is for an indefinite period, and whether assignment to administrative segregation have any collateral consequences on his sentence. The conditions in the state supermax facility at issue in Wilkinson were synonymous with extreme isolation, and nearly every aspect of the prisoners' lives was controlled and monitored. For example, almost all human contact was prohibited, even to the point that the solid metal doors with metal strips along their sides and bottom prevented conversation from cell to cell. The Wilkinson plants were also deprived of almost any environmental or sensory stimuli at the supermax facility. They are required to remain in their cells, which measured 7 by 14 feet, for 23 hours per day, and even allowed one daily exercise period took place in a small room. Finally, though the lights could be dimmed, it remained on all times. So we have a comparison between two prisons and two situations. So we're referring to this situation in Wilkinson and what its conditions are like. And these conditions look very similar. They're not identical, right? So in Wilkinson, they were allowed an hour every day. In the Virginia case, they were not. Most days they spent in their cell 24 hours a day. In the Wilkinson case, however, they had the metal doors with the anti-talking to other prisoner strips, which I'm not exactly sure how that works. I'm kind of interested on a technological level how that works. It's kind of interesting. And also, like the present case, their bulbs also could not be turned off, although they could be dimmed. So we have a situation that's comparable that the Supreme Court has dealt with to show that this situation is one that requires review. However, because severity of conditions alone are insufficient to create a liberty interest, we next turn to indefiniteness. So there's a two-factor inquiry here, and the length of time is an inquiry in relation to the conditions. So although we have very similar conditions, we have to look to how indefinite this is as to whether or not it has a due process problem. Defendants argue the Smith confinement in administrative segregation was not truly indefinite because he was in control of his own fate. By refusing to comply with the grooming policy, he effectively chose not to progress through the step-down program. Smith, on the other hand, says that compliance with the grooming policy was no path out of segregation at all, given his status as a religious objector, which prevented him from cutting his hair, which prevented him from passing the program. And the court says we agree with Smith. So as a practical matter, he didn't have a path out because he couldn't meet the grooming requirements because of his religious beliefs. So, I mean, he's firm enough in those beliefs at least that he's willing to be in isolation for multiple years at a time. So it might be a genuine belief, or at least one that we have to factor into consideration. The duration of Smith's confinement in administrative segregation at Wallen's Ridge strengthens his evidentiary showing of indefiniteness. To be sure, Smith's period of segregation confinement is quite shy of the 20-year period we saw in another case, but 4 years and 3 months is far longer than the 30 days at issue in another case, and a 6-year period in a different case. So this is somewhere in between the unacceptable and the acceptable. So, 30 days is acceptable, 6 months is acceptable, 4 years and 3 months we're less convinced of, 20 years is unacceptable. So yeah, that could be a problem. In sum, we conclude that 3 rationales cited throughout Smith's hearing reviews, when taken together, at least establish a genuine issue of fact as to the existence of a viable pathway out of segregation for Smith, especially when coupled with the record evidence for the duration. Because indefiniteness is one of the factors we must consider in assessing the atypicality and harshness of a prisoner's confinement in administrative segregation, this fact is plainly material to Smith's procedural due process claim. For the foregoing reasons, we vacate the judgment of the district court, which dismissed this outright, and we remand it for further proceedings consistent with this opinion. Thus, that brings us to the end of our discussion of the case of Elbert Smith versus Dennis Collins from the Fourth Circuit from Virginia. In this case, we learned about solitary confinement and what the conditions look like at Virginia prisons, which are pretty typical of solitary confinement, although, as we read, by way of comparison to a different case. Not every state and not every prison does it exactly the same. But there were a lot of similarities we saw for sure. And he was in this for a period of at least 6.5 years, due to, in part, perhaps, assaulting a guard. And he had successfully passed part of the program to be downrated, so he wouldn't have to be in such tight conditions. But he wasn't able to get through the program all the way because he wouldn't cut his hair because of religious beliefs. So the court takes a look at this and says, well, there's a genuine issue of fact as to whether or not he had a practical way out of the program or not. So they send this back to the trial court for further hearings on whether or not all this is true or not, and what should be done about it. But for the moment, at least, that brings us to the end of the discussion of this case.